The Supreme Court will consider whether Kentucky's pro-life attorney general can defend the Commonwealth's law banning dismemberment abortions. The High Court announced in late March they will hear an appeal from Kentucky Attorney General Daniel Cameron, who wants to defend a pro-life law that lower courts struck down. The Kentucky law concerns the legality of second trimester abortion procedures, but the Supreme Court will not rule on the law itself. Instead, the question at the center of the case is whether the Attorney General, a pro-life Republican who supports the law, can intervene to defend it in court. The dismemberment abortion ban was signed by former Governor Matt Bevin, a Republican, but it was struck down by lower courts as unconstitutional. The current Kentucky governor, who is Democrat Andy Beshear, has declined to challenge the lower court's decision. Joining us now on Zoom is Kentucky Attorney General Daniel Cameron. Welcome to the show. Attorney General, I understand the Supreme Court case will really focus on a procedural question, but what are the potential consequences of this case? If the Supreme Court rules in your favor, will dismemberment abortions be banned in Kentucky? Explain what's at stake here.
Well, thank you, Catherine, for having me on. This case is about the responsibility and the opportunity for a state attorney general to intervene and defend pro-life legislation that has been passed by our General Assembly. House Bill 454 was passed nearly 3 years ago, and it bans live dismemberment abortion procedures known as D&E, dilation and evacuation procedures. And basically, what we want to do in Kentucky through our General Assembly is show compassion and humanity in the midst of a gruesome procedure, ensuring that a child is not alive during that procedure. This was passed, as I noted, 3 years ago. We have taken it upon ourselves in this office to defend this law. We were working in consultation with Governor Beshear's office. He at some point decided to wash his hands of this important legislation. It is now our responsibility to try to intervene to make sure that we're continuing to defend this law. The Supreme Court will have an opportunity in the fall to hear this case in terms of our role and ability to intervene. And if we get a favorable ruling there, if we're allowed to intervene to defend this law, we'll then go back to the Sixth Circuit Court of Appeals and continue to defend this pro-life legislation.
As you mentioned, the Kentucky pro-life law is about banning dismemberment abortions, which is when an abortionist uses instruments to dismember and extract a baby from a woman's uterus during the second trimester of pregnancy. Critics say dismemberment abortions are not a medically accurate term. What's your response to that, and why, in your opinion, is this pro-life law worth fighting for all the way up to the Supreme Court?
Well, I've said from the beginning, my role as the Attorney General is to defend the laws that are duly passed by our elected representatives in the General Assembly, meaning our state House and our state Senate. The folks here in Kentucky have made an assessment that they value life and they value humanity and compassion as it relates to live dismemberment abortions. And so this piece of legislation in particular reflects that humanity and compassion in saying that a child, again, this is a gruesome procedure and no one wants to see it, period. But if it is to happen here in Kentucky, we want to make sure that that child is not alive during it because as was talked about and discussed at the trial court level, it is a painful procedure. We want to make sure that those painful procedures aren't at the expense of a live child. It is a sad and terrible situation. And I'm hopeful that we'll be able to defend this law in the Sixth Circuit if we get a positive ruling from the United States Supreme Court.
Attorney General, you are obviously your state's top lawyer. Last year, you were on former President Donald Trump's short list of potential Supreme Court nominees. I'm curious, from your perspective as a pro-lifer, as a lawyer, what role do you see the Supreme Court having in the pro-life movement and bringing an end to abortion in this nation?
Well, I think they have the end-all, be-all in terms of say as it relates to what abortion looks like and what pro-life looks like in the coming years ahead. Obviously, the decision that was made in Roe v. Wade has had an outsized impact on the pro-life movement since its inception. And so this Supreme Court has a chance, whether it be on live dismemberment procedures that our legislation has said that we need to stop and make sure that there's humanity in that process, or waiting period laws that come up. There was just a decision made in June Medical, which gets rid of a balancing test and moves back to some of the Casey factors that were considered in 1992. And so this court has an opportunity, in my judgment, to really look at these issues again from a new perspective. Obviously, we've got some new justices on. Amy Coney Barrett, Justice Barrett, has recently come to the bench. And so it'll be an interesting time for pro-life legislation.
This is my first time being able to speak with you, Attorney General. Have you always been pro-life, and what does this issue mean to you?
Well, this is an important issue for me. Obviously, my faith background and perspective guides and informs my decisions on pro-life issues. I think it's important for Christians to be involved and Catholics to be involved in this conversation because we recognize the humanity of those that are in the womb and how important it is that we protect those who cannot speak for themselves, who are alive in the womb. That's why when it comes to this live dismemberment abortion bill that we have here in Kentucky that bans it, that's why when it comes to discrimination measures in abortion procedures, where it gets that here in Kentucky as well. And so from a faith perspective, very important, but also from a responsibility as the Attorney General to make sure that we're defending the laws that are passed by our General Assembly. I believe wholeheartedly in my responsibility to carry out that mission as the Attorney General. We're going to continue to do so here in the coming years.
And we will be following this case closely. Daniel Cameron, Kentucky's Attorney General, thank you for your time.
Thank you, Catherine.
And joining us now on Skype is Mallory Quigley, Vice President of Communications for the Susan B. Anthony List. Mallory, welcome back. Let's just take a step back. This Supreme Court case involves Kentucky's dismemberment abortion ban. Can you first explain to viewers the reality of this type of abortion procedure and why this Kentucky pro-life law is important?
Yes, well, this is a very well-named law, Catherine. It prevents abortions, as the Attorney General explained, after a certain time period when the procedure that they're going to use does indeed take apart the body of the child limb by limb. So it's important that we talk about the reality of abortion and the reality of how this procedure is accomplished. As you and the Attorney General were saying, the Supreme Court case that is before them, the question is before them right now is really procedural about whether or not the Attorney General is going to be able to defend that law that was passed with bipartisan support in the Kentucky General Assembly. And the legislators are just using common sense, really plain language to describe what kind of abortion we're talking about here and what the unborn child is experiencing in that moment.
Kentucky's Attorney General Daniel Cameron just explained and discussed the potential consequences of this case, Cameron versus EMW Women's Surgical Center. Mallory, why is it important the pro-life movement keeps a close eye on what the Supreme Court does here?
Yeah, well, we've been waiting for a while now for the court to rule on abortion. This will be the first, the next time that the court's going to have an opportunity to take some action on abortion, and it will just be an indication of where they're at. I think it would be really encouraging if they rule that, yes, the Attorney General, who ran as a pro-life AG in a very pro-life state, who wants to defend a law that was passed by the legislator. This is the way that the three branches of government ought to be working at this point in time. So it will be very encouraging if the court does allow the AG to defend the law, and it will give us the beginning of, it will begin to show us exactly how the court is going to speak out on these kinds of issues. Like he mentioned, we've got a new Supreme Court thanks to former President Trump.
Speaking of the Supreme Court, President Joe Biden ordered a 180-day study of adding seats to the Supreme Court. Supreme Court Justice Stephen Breyer just warned against court packing, But Mallory, do you foresee that potentially happening, and what does that mean for the pro-life cause?
Well, as we've seen over and over, the pro-abortion movement and the Democratic Party, unfortunately, they just want to change the rules when they don't get the results that they want. So for decades, the pro-life movement has been working towards the accomplishments that we made under President Trump in terms of being able to appoint and confirm pro-life Supreme Court justices as well as lower court judge appointments. And now the goal of expanding the court would be to dilute that progress. That's what the pro-abortion movement wants. On this commission, it includes former general counsel for NARAL, law professor Larry Tribe, a longtime pro-abortion activist. So there are people with a policy position here that they want to expand the Supreme Court in order to dilute the gains that we've made under President Trump and have an impact on policy, which would be the continuation of Roe versus Wade.
That's some really important insight there. Mallory Quigley with the Susan B. Anthony List, thank you as always.
Thanks, Catherine.